Everyone, and welcome to this CAASA webinar. Today we're going to go through the draft new version of GCC 2023. Just by way of background, to give you some context, the CRDB has 4 recommended contracts that they've endorsed: the NEC, the FIDIC, the JBCC, and the GCC. And the GCC is a homegrown South African contract used for construction works. CAASA, which is the South African Institution of Civil Engineering, has a sub-branch called the Project Management Division. And underneath the Project Management Division, there's a committee called the Contractual Affairs Subcommittee, which I am part of. And one of the one of the responsibilities of the Contractual Affairs Subcommittee is to look at the general conditions of contract. So to date, we've had 3 editions of GCC. We've had the 2004 edition, which was the first edition, the 2010 edition, the second, and the 2015 edition, the third. So as you can see, periodically, the general conditions of contract are updated for very good reasons. Things change. The way clauses are treated change, the very nature of construction changes, and contracts need to be able to change to adapt, to cater for those sort of things. About 18 months ago, we discussed commencing with reviewing GCC 2015. So it's been quite a process. We've gone through a number of various stages, which I'll just touch on briefly before we go into the actual meat of the discussion. The CAASA committee consists of 9 members. In the past, the driving force behind GCC has been Willie Claassen, really a doyen of the South African construction industry, and he's the one that's driven the previous versions of GCC. In this instance, we decided to do it slightly differently, in that we would divide the 9 clauses between the 9 CAASA members, create little subcommittees, and each CAASA member then would deal with a clause in the GCC, clauses 2 to 10. We would then have regular feedback, regular meetings. So that was the process we adopted, on the basis that, the GCC works. It works very well. So we don't want to do a major rewrite. We just want to improve on the parts of it where it might be lacking, or where the parts need to be changed to adapt to modern times and modern interpretations. So that was the sort of first philosophy. We're not going to have a complete rewrite in the sense of sort of FIDIC has done, where they've greatly expanded the Red Book and the other books. It was more, let's say, fine-tuning. No contract is perfect, but certainly we try, and some GCC 2015 had some flaws, so clearly we could rectify those in this latest version. So after the working groups had done their bit, we then decided, well, let's do a comparison then between GCC 2015 and GCC 20, as we called it at that stage, GCC 2022, to try and see if we actually need these changes. So that was the second comparison we did, and that's what we're basically going to focus on today, the comparison between the 2015 version and now what we call the 2023 version. And that went through a number of iterations as well. So eventually, the draft contract that we've sent out, which we call draft final, is actually revision 8 of the process that we've gone through. So it's been quite extensive, but it's been done entirely within the CAASA committee. We haven't taken it outside the CAASA committee yet. The CAASA committee consists of a variety of people. We've got some lawyers that are engineers. We've got some lawyers that are not engineers. We've got some engineers. We've got some contractors. We've got a broad scope of people on the CAASA committee that I think bring various backgrounds to try and make it as balanced and as a fair balance of risks as possible. So some people are looking at it from a contractor's point of view, others are looking at it from an employer's point of view, and still others from an engineer's point of view. So out of that whole melting pot, we hope we've got a contract that's going to be a success and it's going to serve the industry going forward. I know there's some CAASA members in this meeting today, so I'm hoping that if I get anything wrong, they will pipe up and tell me and jump in and take any of the flack that I might get. So just as some basic principles, we tried to make it gender neutral. We might not have succeeded entirely yet. I know some people have pointed out places where we still have the clause he or she or something like that. So, but certainly we haven't had the whole contract proofread yet. That's the next step in the process. Once we've received all the comments by the end of March, then we'll go through those comments. I think our intention is possibly then to set up another session with a wider audience to go through the comments and say why we believe, yes, we've incorporated them, or no, we haven't incorporated them. So that would be the next step. And then after that would be the proofreading and hopefully publishing GCC 2023 this year for use. Of course, it's always important. I mean, GCC 2015 had a guide that accompanied it, and we're working on the same thing for GCC 2023. The guide will probably come out a bit later than the actual publication of the contract itself. So if we can start then, let me share my screen. Sorry, excuse me. And can everyone read that? Okay, this is clause 1. There was no specific group that dealt with clause 1. The reason being that really clause 1, once we dealt with the other 9 clauses, they really fed into clause 1. But there's some differences I'd like to point out to you. Firstly, here in clause 1, we've inserted the word agreed to in writing between the parties. Now that's quite important. What we've tried to do in GCC 2023 is try and do away with oral communications. The main communication should be in writing. The second one is, you'll see now, instead of the due completion date, we've got a thing called the due practical completion date. And that will become obvious as we go further on into the GCC, the various other clauses. So the due contractual completion date means the date of expiry of the time state and the contract data for achieving practical completion of the works. In the past, there was a whole load of things that happened at due completion. For instance, insurance of the work stopped, the employer took over the works, the insurance of the work stopped, the bond was returned, those sort of issues. But now we have a distinction between practical completion, where certain things happen, and completion, where other things happen. That was clause 1. We've also introduced, in terms of modern day communications, we've introduced clause 1.2.1.3, which caters for communication sent by email, which now reads that if sent by email, then 1 day after the written communication has entered the recipient's domain. I believe that's in terms of the Electronics Communication Act. And I think that as far as clause 1 is concerned, those are all the major changes. So let me try and let me just stop sharing my screen. Just close this down. There's clause 2, right? This is clause 2. Okay, clause 2. Let's make it a bit bigger. All right, in clause 2, we've introduced 2 what we believe is good project management concepts. The first one is in this new clause 2.1.1.1, which is really taken from the NEC, stating that the contractor, the employer, and the employer's agent shall carry out their contractual obligations in an honest, fair, and reasonable manner, and in a spirit of mutual cooperation. So just spelling out what we expect, how the parties will behave. And then we've also introduced, taken a leaf from the NEC, and now the new FIDIC is an advance warning. So here we're saying that the contractor, employer, and employer's agent shall notify each other in advance, in writing, upon becoming aware of any event or circumstance which may adversely affect the time, cost, or quality of the works. The employer's agent shall give effect to clause 3.2.2 to avoid and mitigate the effects of such event or circumstance. And clause 3.2.2 requires the employer's agent to convene a meeting with the contractor and employer to see how they can mitigate the effects of the likely happening if the advance warning materializes. Then really the only other important consideration under this clause is done at clause 2.7.1. Previously read that neither the contractor nor the employer shall, without the written consent of the other, assign the contract or any part thereof or any obligation under the contract to cede any right or benefit thereunder. What we've done is we've amended that clause slightly to include the situation where, other than where the contractor intends to cede payment against a signed payment certificate, then the consent of the employer is not required in that instance. Okay, if we can move on, clause 3. Okay, in clause 3, clause 3.2.2, which we alluded to earlier when we spoke about the advance warning. So this wording now reads, whenever the contract requires this clause to be applicable, or the employer agent intends in terms of the contract to exercise any discretion or make or issue any ruling, contract interpretation or price determination, he shall, acting impartially, first consult, and preferably jointly. And we want to promote this concept of consulting jointly with the employer and the contractor. I mean, I know in the past that employers' agents are reluctant to do so. They consult with the one party and then with the other party. But really, if we want to try and resolve problems, disputes at the lowest level possible, it is recommended that the parties consult jointly. So preferably jointly with the contractor and the employer in an attempt to reach agreement. If agreement is reached, such agreement shall be signed by the contractor and the employer. Okay, moving down. Again, clause 3.3.1. The employer's agent shall be entitled by written notice to the contractor to appoint a person as the employer's agent's representative, who shall be a competent person, appropriately qualified for the scope of work, and who shall be based on site while the works are being carried out. The employer's agent shall have the power to, by further notice, from time to time, to terminate or change such appointment. So here the emphasis on the employer's agent's representative must also be competent for his functions and based on site. And you'll notice that here we replaced the word disapprove, it's replaced by the word reject, and here we put in a new clause. Really, I mean, I think that it is pretty standard that regular site meetings are held, but to emphasize it, we've included this clause. But also emphasize the fact that unless otherwise agreed or recorded, site meetings don't have a contractual basis. Site meeting minutes don't have a contractual basis. Clause 4. Okay. Here we've replaced the word approved by accepted, and this happens in a number of instances. So it's no longer that the employer's agent approves something, but that the employer's agent accepts. Under 4.5.3, there's an addition to this clause. It reads, the contractor should be responsible for obtaining all requisite consents, permission, and permits for carrying out the works arising from the provisions referred to in clause 4.5.1.1 and arising from the approvals referred to in clause 4.5.2. if the contractor has diligently followed the procedures laid down for obtaining the consent, permission, or permit, and the works are delayed due to the relevant authority's failure to issue such consent, permission, or permit, the contractor shall, in respect of the delay to practical completion and or to prove an additional cost, be entitled to make a claim in accordance with clause 10.1. I mean, we're reliant on the authorities to issue certain permits, approvals, consents, and despite the contractor's best efforts in making sure that the documentation is completed correctly and submitted timelessly, delays happen. I mean, we have delays with Eskom trying to relocate power cables and all those sorts of issues. And those really can't be the fault of the contractor if he's complied with all the documentation and the time frame required. This clause here, this is clause, this is an addition to clause 4.8.2.3, provide access to any part of the work to allow employer, his contractors, or any authority to carry out his work. So this clause is added to cater for the situation of the contractor instructed to give access to others. Okay. We've also included the word data in lots of places. So instead of in the past where it said provided in the contract, we now say it's provided in the contract data. Contractor superintendents. This clause has been reworded to read that the contractor shall appoint a competent and authorized agent or representative approved of in writing by the employer's agent, which approval may be at any time be withdrawn in writing, hereinafter called the construction manager, who shall be on site at all times when work is being performed, or when the employer's agent shall with reason require the construction manager's presence. So that's really clause. I just want to get to. Can I do that? Oops, no, let me get back. Excuse me, I've just fiddled with my computer. Tiffany, can you see clause 5?
Yes, I can.
Okay, sorry. All right, so clause 5. We've introduced clause 5.1.2, which says that the stipulated period within which any action is required to be taken may be extended in writing by mutual agreement between the employer's agent and the contractor before the expiry of the stipulated period. So that's been added to extend the time within actions that we taken and delay the effect of a time bar if the employer's agent and the contractor agree to it. So that was one of our first additions, one of our first changes. Under 532, if the documentation referred to wasn't provided within the prescribed time, the employer had the right to terminate the contract in terms of clause 9.2. He still retains that right, but we've also added now that he may extend the time for completion, so for the time for submission with any adjustment to the due practical completion date. So you can either terminate the contract or extend the time for completion. Okay. Okay, and here we've got the amendment. We've now got the due practical completion date, as opposed to the old date on the previous version, which was the practical completion date. Here we've got, before commencing the works, the contractor will deliver to the employer's agent a program of the works as part of the documentation required in clause 531, should it become clear that the accepted program, not the approved program, does not reflect actual progress, the contractor should deliver to the employer's agent an adjusted program. So that's changed the wording of clause 5.6.1. If we go to 563, the employer's agent shall, within 7 days of receipt of the contractor's program, accept such program, or giving his reasons, instruct the contractor to amend it, failing which the submitted program shall be deemed accepted. And then 565, when instructed by the employer's agent, the program shall be adjusted by the contractor. So really there's various stages of adjusting the program. The program's updated on a monthly basis. The program is updated whenever the progress of the work doesn't actually reflect the accepted program, and the program's updated when the employer's agent instructs the contractor to do so. Oops. Oops. I don't know what's happened with this. Seems as if. Goodness. Okay, hold on. Sorry, my apologies, but it looks like using Adobe, it hasn't pulled through the whole document. If you just bear with me a minute. Okay, my apologies. It looked like when it pulled it through, it didn't, for some reason, the whole document wasn't here. So under clause 5, clause 5.9.2 now reads, the employer's agent shall, in accordance with the accepted program, deliver to the contractor further information, drawings, and or instructions necessary for the proper and adequate construction, completion, and defect correction of the works. So previously it was delivered to the contractor from time to time. Now we've clarified that by saying it should be in accordance with the accepted program.
Okay, under 5.11.1, the time frame from 14 days has been changed to 7 days. Under 5.11.2, the time to 84 such payment period for the contractor, allowing the contractor to suspend the works from 84 days, we reduced that to 28 days. And then during the suspension of the works, during the suspension of the works, the contractor is responsible for protecting works as far as is necessary and shall remain liable for the care of the works and of all plant and materials on the site intended for incorporation into the works, which clarifies the contractor's responsibility and what he's liable for. Okay, again, this is where the works have been suspended. So if such permission is not granted within 28 days, that period has been reduced to 14 days. And in this clause here, due completion date in 5.12.1 is replaced with due practical completion date. Okay, 5.14.1, we now deal with practical completion. The contractor has been allowed to receive a certificate of practical completion when the works have been completed in accordance with the requirements for achieving practical completion stated in the contract data. And then 5.14.3.2, upon the issue of the certificate of practical completion, the contractor's obligation to ensure those works certified as practically complete shall cease. Saying this new clause crystallizes responsibility for ensuring the works that have been certified as having achieved practical completion. That responsibility shifts from the contractor to the employer. And the employer shall be entitled to take occupation of the completed works, provided the contractor is given access to complete the incomplete works and rectify any defects in terms of the contract. Clause 5.56. This is the certificate of completion. It says the employer's agent may issue such certificate, leaving any work and or rectification of certain defects and or the clearing of the site to be completed by a later date, stated in the certificate of completion. The contractor should be obliged to complete the work listed by the date stated in the certificate of completion. The contract, failing which the defects liability period shall be extended by the amount of additional time taken by the contractor to complete the whole of the works, and the terms of clause 7.8 shall apply before necessary changes have been made. So certain works can be postponed till after the certificate of completion has been achieved, but then must be dealt with. Okay. Under 5.14.7.1, the old wording was that the performance guarantee should be returned to the guarantor, and that very rarely happens in real life. It's the contractor that goes and gets the performance guarantee from the guarantor and provides it to the employer. So the rewording now has been that the original performance guarantee, if any, should be returned by the employer to the contractor within 14 days. And 5.14.5.5 in under GCC 2015, it catered for the fact that insurance of the works only ceased on the completion date. So this clause has now been deleted because we deal with it under practical completion. All right, there's some other, as you can see in the comments column, there's some other wording changes, making the clause read better, but the substance of the clause hasn't really changed. Okay, clause 6. Under 6.2.2, if the contractor failed to select security provided within the time period, if the performance guarantee differed substantially from the pro forma, then it was deemed that the employer had selected security of 10% retention of the value of works without limiting the employer's right to terminate the contract in terms of clause 9.2. We've done away with that deeming provision, so that's no longer the default provision. It's really up to the employer then. So if the contractor fails to select the security to be provided, or if the contractor fails to provide the selected security from the time period stated in clause 532, or if the performance guarantee shall differ substantially from the pro forma, the employer may elect to terminate. Okay. And in the GCC 2015, it spoke about the return of the performance guarantee when the works have been completed. We just clarified that, say, the performance guarantee shall be held valid until such time as the certificate of completion has been delivered. All right. Clause 6321. The further clarity is provided by stating that if it shall not be a variation order, so this is where the contractor fails to confirm a variation order, and specifically state that as a result thereof, the provisions of clause 6.4 shall not apply. So if the contractor fails to confirm such instruction or order within the 7-day period, such instruction or order shall not be a variation order, and the provisions of clause 6.4 shall not apply. The valuing of variation orders is also GCC refers to additional work. So we've just clarified that the value of all variation orders and additional work, where reference is made to this clause as to how additional work will be valued and paid for, shall be calculated by the employer's agent in accordance with the following principles. Under 6412, we've made a provision to include the general items, where workers have similar or using the rates and prices as a basis for the evaluation. And then clause, under 6415, should the contractor experience a delay as a result of a variation order or instruction to carry out additional work, which complies with the provisions of clause 5.12, the contractor shall be entitled to claim in accordance with clause 10.1. Okay, we've just clarified clause 6.4.2. Should the employer's agent fail to provide the valuation within the agreed period, or should the contractor disagree with the valuation, the contractor has the right to raise a dissatisfaction claim in terms of clause 10.2. Clause 6.4.3 has been omitted. The procedure is clear. Should the valuation not be received by the contractor to issue a dissatisfaction claim, the contractor to issue a dissatisfaction claim in terms of clause 10.2 and not a proven cost, additional cost claim in terms of clause 10.1. Then under clause 674, Previous wording was the measurement made by the employer's agent or approved by him shall be taken to be the correct measurement of the work for the purpose of the payment certificate in respect of which the measurement has been made. So this has been amended to read that the measurement made by the employer's agent or approved by the employer's agent shall be taken to be the measurement of the work for the purpose of the payment certificate in respect of which the measurement has been made. So the measurement will be included in the payment certificate, but the measurement is subject to change and is no longer taken to be correct. Six, 8, 4. Okay, so the clause has been broadened to include reductions or increases in the time for achieving practical completion, which reductions or increase in time is to be determined by the employer's agent after consulting with the employer and the engineer. Okay. And then under clause 610.15, we've made a provision nowadays. I mean, lots of employers won't pay for material on site unless the contractor has provided a material on site bond as security. So we've included a provision allowing the employer to request the contractor to provide a payment guarantee in the form of a material on site bond, which is quite common practice nowadays. And then just in terms of certification, clause 610.4, which is virtually the same as the wording of TCC 2015, except we've added the proviso that for the purpose of certification and payment, the provisions of clause 5.1.1 shall not apply. Clause 5.1.1 deals with non-working days, the Christmas shutdown, public holidays, etc., etc. So in essence, what we're saying is that in terms of the time frames to issue payment certificates and to pay, those special non-working days, those public holidays don't apply. They can't be taken into account. And then under clause 610.7, we've added the wording here that says, other than for payment certificate issued in accordance with clause 610.8 and 610.9, the employer's agent may, by any payment certificate, make any correction or modification of any previous interim payment certificate which has been issued by the employer's agent. And then clause 611, variations exceeding 15%, we've deleted this entire clause. Clause 7, quality and related matters. These are more just small modifications to make it read better. There's nothing really that is fundamentally changed in this clause. For instance, just the word unsuitable includes, so instead of outdated and obsolete, the word unsuitable has been put in there. As set out in the contract, instead of in accordance with the scope of work. And here we can allow for the inclusion of the wordings or as may have been instructed by the employer's agent. And added this wording to allow for uncovering and restoration of work when the instruction of that work was issued after commencement of the contract. So as you can see from clause 7, there are really minor changes to the GCC 2015 word. Clause 8. Which is risk and related matters. Under 813, we've added the wording of other associated infrastructure. And then under 821 now is where the care of the works, so from the date on which the site is handed over to the contractor to the date of issue of the certificate of practical completion, the contractor takes full responsibility for the care of the works, provided that the employer's agent should issue a certificate of practical completion in respect of any part of the works. The contractor should cease to be responsible for the care of such part, and responsibility therefore shall pass to the employer. And under 8, the accepted risks, no longer called the employer's risk, accepted risks. We've added in a state of emergency, a state of disaster, or any other declaration by the government that prevents the contractor performing its obligations in terms of the contract. That's a new clause. And then 8311 is just worded better. Ionizing radiation or radioactive fallout or contamination by radioactivity from any nuclear fuel. So just try to word that better. All right. Just 8.4.3, we've added the wording, we've moved the wording in the contract from clause 8.1 to here. Existing clause 8.1.4 is renumbered 8.4.3. This section of the contract deals with various indemnities. So this was the logical place to put it. So the contractor indemnifies the employer against any liability arising out of the contracted non-compliance in terms of clause 8.1. Clause 9, which is termination of contract. There's some wording changes, as you can see here at clause 9.1.1, just changes some minor wording. Again, adding some wording if during the currency of the contract, any of the accepted risks set out in 8312, including 8316 occur, or the cost of the works is included. Down here, we just converted 20 consecutive working days and 40 working days to calendar days, since the GCC recognizes calendar days and not working days. So 28 consecutive days and 56 days in aggregate. And 914, it was just reworded to give it for clarity. A new sentence added at the end. So should the contractor fail to notify within the 14-day period all rights to recover any additional costs shall be forfeited. Then this is amplified to include instruction from the employer's agent. The contractor shall, if instructed in writing by the employer's agent, repair and make good any damage to the works. Those clauses we worded for clarity. Okay, so another significant change we've done to this clause is to differentiate between those breaches that cause automatic termination and those breaches that require the employer's agent to give the contractor notice to rectify. So these first lot are breaches that lead to summary termination. The business rescue process has been added in, the breach. Then the employer may, by written notice to the contractor, terminate the contract. Then the second section is where the contractor is giving a period to remedy his breach. New clause 9.22217 has failed to implement the adjudication board's decision without delay in terms of clause 10.5.4. When the employer may, by written notice to the contractor, referring specifically to this clause, give notice of its intention to terminate the contract. Just 923 just reworded to clarify. 924, if the contract is terminated either clause 9.2.1 or clause 9.2.3, the employer shall instruct the contractor to vacate the site and hand it over to the employer. And then we've added these new clauses, 9.2.9. So upon such termination, all the provisions of the contract, including this clause, shall continue to apply for the purpose of resolving any claim or dispute and determining the amount payable to either the employer or by the contractor to the other of them. Business rescue is added. And then we've added this rider 9 to 11, which says the right to terminate may not be exercised by the employer where the employer is a material breach of the contract. Okay, similar under clause 9.3, termination by contractor, we've again divided those material breaches that do not require the contractor to give notice prior to termination and those that require him to give notice prior to termination. So we see that the contractor does not need to provide notice where the employer becomes bankrupt or insolvent, or goes into liquidation, or the employer, including his personnel agents, demands or extorts any bribe, gift, gratuity, commission, or other thing, then the contractor may terminate by written notice to the employer. Again, similar provision for the contractors where the employer has failed to implement the adjudication board decision without delay in terms of clause 10.5.4. Right, move on. Again, the wording business rescue has been added. The employer going into business rescue. And again, a similar provision against the contractor. The right to terminate may not be exercised by the contractor where the contractor is in material breach of the contract. Okay. Clause 10. In GCC 2015, the contractor had submitted detailed claim within 28 days of the event. We've now adopted the approach that he must provide notice within 28 days. So you see the 10.1.1, where in the past read the contractor shall within 28 days after the circumstance, event, act, or omission giving rise to such a claim has arisen or occurred, deliver to the employer's agent a written claim referring to this clause and setting out, etc., etc. New wording reads: the contractor shall within 28 days after the circumstance, event, act, or omission giving rise to such a claim has arisen or occurred, deliver to the employer's agent a written notice of its intention to claim, referring to this clause and setting out, etc. So therefore, there's a new clause being introduced, 10.1.1.2. The contractor shall, within 28 days after delivery of such a notice or such other reasonable period as the contractor may propose in writing, and to which the employer's agent agrees in writing, deliver to the employer's agent a written claim referring to notice in terms of clause 10.1.1.1 and setting out the contents of his claim. This is where the event is of an ongoing nature. The contractor in the GCC 2015, the contractor 28 days after the event or circumstances had ceased to deliver his final claim. In this instance, the 28 days will apply, or such other reasonable periods the contractor may propose in writing, and to which the employer's agent agrees in writing, deliver his final claim. Previously, GCC 2015 read that all facts and circumstances relating to the claims shall be investigated as and when they occur or arise. For this purpose, the contractor shall deliver to the employer's agent records in a form approved by the employer's agent. We've done away with that wording and said, for this purpose, the contractor shall deliver to the employer's agent records of all the facts and circumstances which the contractor considers relevant and intends to rely upon in support of its claims. And then 10.134, and we've deleted the words shall and conclusive. So what we're saying now is each record of an agreed fact in terms of clauses 10.133 may in any dispute be submitted as evidence of the fact concerned, and not conclusive evidence. Ten 136. Again, we've changed the wording here. So the employer and the employer's agent and the contractor shall, in any proceedings in accordance with clauses 10.3 to 10.11, be entitled to give or lead evidence or rely on any fact or circumstances not recorded in terms of this clause. I mean, it's common that arbitrations and adjudications start from afresh, and that the contractor and the employer introduces additional information that didn't necessarily form part of the contractor's claim or the records that the party took at the time. Okay. We had a long discussion about how quickly employers' agents and to a certain extent employers throw in the time bar. So what we've tried here to cater for those circumstances where the contractor can dispute the fact that his claim or his notice of claim has been time barred. So the wording is if the employer's agent considers that the contractor's failed to give the notice of intention to claim in terms of clause, I think it's 10.111 and not 10.112, but we'll check that. Within the period of 28 days, the employer's agent shall, within 7 days of receiving the notice, give a written notice of failure and provide reasons. If the employer's agent does not provide a notice of failure within the 7 days period, the notice of intention to claim shall be a valid notice. If the employer's agent gives a written notice of failure and the contractor disputes such notice, the contractor shall be entitled to deliver a dissatisfaction claim in terms of clause 10.2. Regardless of whether or not the employer's agent has given a notice of failure, if the employer disputes the notice of intention to claim was provided within the 28-day period, the employer, without limitation to his other rights, should be entitled to deliver a dissatisfaction claim in terms of clause 10.2. Change really to the wording there. where the employer's agent did not deliver a ruling within the time period stipulated in clause 10.1.5 or such other agreed periods in accordance with clause 10.1.5.1, the claim shall be considered to have been rejected. This is to cater for the situation where the employer's agent is non-responsive and the contractors just kept hanging on the line and hanging on the line, waiting for the employer's agent to give his ruling. Uh, 10.3. So where the employer's agent, this is under 10.2, where the employer's agent fails to deliver a ruling within period stipulated in clause 10.2.3. This in relation to a dissatisfaction claim, the claim shall be considered to have been rejected. 10.3.1.3, the dispute notice shall be delivered in terms of the time period in the clause 10.1 or 10.2. Failing such delivery, the party shall have no further right to dispute the matter. Okay, 10.4.1. Again, we had lots of debate around this clause, and really we're trying to encourage the parties to try and reach agreement at the lowest level possible before the dispute escalates. So what we're encouraging here is that upon delivery of a dispute notice, either party may, by written notice to the other party, propose that the dispute is resolved through amicable settlement. So amicable settlement being really the sort of the lowest basis of resolving a dispute if the outside the employer and the contractor not reaching an agreement, or the contractor and the employer's agent. We've given it a time frame, so we said, should amicable settlement proceedings fail to commence within 14 days of the proposal, it shall have been rejected, simply because, again, some unscrupulous employers or those sort of people will use amicable settlement just as a means of delaying the process. To clarify, under 10.4.3, that if amicable settlement
I think we have lost Norman. I'll just try and see if we can get him back. Hi all. Okay, Norman is just he's just going to dial back in. I just believe they had load shedding and the UPS is just kicking in. So if you could just be a little bit patient with us, he should be back in the next minute. Hi, Steve. I see you've raised your hand. I can allow you to talk. You can just unmute your microphone.
Wonderful, thank you. I was just wondering if it was just me or everybody. Is that the only way we can communicate? I've put some questions and answers, and they haven't. I don't know if someone will look at them later. And then the other thing is that the chat is disabled. Is that correct? Deliberately.
Oh, that's a good point. I actually don't see the. No, the chat is there. So just on your first point, yes, I'll ask Norman to go through all the questions once he's finished presenting. And if anyone does want to ask a question live, if they can just raise their hands and then I'll give them permission to speak.
Okay, my chat still says disabled, so I don't know, maybe it's just me. Maybe someone else can just give us a signal there.
Okay. Yeah, from my side, the chat is normal. I'm not sure if it's just then yourself. Yeah. Okay, Barry, I see you've raised your hand, so I'm just going to allow you to speak. You can just unmute your microphone.
Sorry, apologies for that, and good morning, everybody. Yes, we're also disabled this side, as Steve was mentioning. Just thought I'd bring that to attention for chat.
Okay, thanks for letting me know. I'll look into that. I'm not too sure why, if I've done something or Zoom has changed the setting, but I'll look into that for everyone. I think for now, if everyone, if you do have a question, just put it in the Q&A, or as I've mentioned, just raise your hand when we get to the question portion, and I'll just allow you to be able to speak. And I think Norman might be struggling a bit to get back online, but I'll give him another call in a sec just to see. Hi, Norman, I see you.
Yeah, my apologies, everyone. We just got load shed at 10 o'clock, and the UPS took a little bit of time to kick in. Shall I carry on, Tiffany?
Yes, please, you can carry on. What we did just say is we'll, you know, if there are a few questions in the
Yes.
Q&A box, which you'll deal with afterwards.
Yeah.
And then I can also allow, if anyone raises their hands, that they can ask a live question.
Wonderful. Okay, we're in clause 10.5. Can you see it?
I can currently see your, it's not open as a PDF. I can see the list of the clauses.
I did open it as a PDF. Well, let me just share it. Stop share. Let me share again. Share screen. There.
Yes.
It come up now.
Yes,
Okay.
I can see that. It's perfect. Thank you.
Apologies, everybody. Wonders of ESCOM. Okay, so we were discussing clause 10.5.1 and the provisions for adjudication boards, being a standing adjudication board and an ad hoc adjudication board. And that the standing adjudication board had to be appointed within 56 days of the commencement date. And there was a recent court case where the standing adjudication board was not appointed within 56 days. And the judge ruled that the matter then could not proceed to adjudication, could not be dealt with under ad hoc adjudication. So to clarify that situation, we've added in clause 10.5.1.1, which says that provided that should no standing adjudication board be appointed within the said time period, an ad hoc board shall be appointed in terms of clause 10.5.2. So that's really to clarify that matter. And then 10.5.2, if the contract data does not provide for dispute resolution by a standing adjudication board, the dispute shall be referred to an ad hoc adjudication board appointed by the agreement between the employer and the contractor. And then just to clarify that, failing appointment by agreement within 14 days, an ad hoc adjudication board shall be appointed in terms of clause 10.9.1. Okay, again, just to clarify, the adjudicating board shall consist of the number of members stated in the contract data, failing which the number shall be 1. So if the contract data is silent on the matter, then the DAB board shall be 1. And 10.6.1.2, we've just amended the wording slightly. It previously read that a party shall not dispute the validity or correctness of the whole or a specified part of the decision before 28 days or after 58 days from receipt of the decision. We've now said it's from the date of publication of the decision. And then quite an important consideration under clause 10.6.1.3, which says, should a party fail to comply with the decision of the adjudication board, the defaulting party waives its right to dispute the decision and refer the dispute to arbitration or court proceedings until such time as it has complied. So we can't have the situation where a party simply ignores the adjudicator's decision, does not enforce, does not comply with the decision, and simply refers the matter to arbitration or to adjudication, forcing the contractor to have to go to court to get provisional sentence or to get the adjudicator's award upheld. (10.6.3). We've deleted out the words, the employer's agent's ruling shall be final and binding. We've deleted the employer's final and binding. Arbitration. Again, the encouragement to attempt amicable settlement. And here we just added in, sorry, my apologies there. And made reference to the applicable legislation. So there's the Arbitration Act 42 of 1965 as amended, and then we also have the International Arbitration Act 15 of 2017 as amended, which both apply to arbitrations in South Africa. And then furthermore that, or any legislation and substitution of either as applicable. Under clause 10.9.1, so here we've replaced the word nominated by the president of, or his nominee of the South African Institute of Civil Engineering to the word appointed. He'll be appointed on the behalf of the parties and not nominated. And then lastly, clause 10.11.1 reads clause 10.1 to 10.11 are separate divisible agreement from the rest of the contract and shall remain valid, applicable, and enforceable, notwithstanding that the works may have been completed or the rest of the contract may be void or voidable or may have been terminated for any reason. So those then are the clauses. as you will notice when we sent out the draft, there's also the contract data, changes to the contract data. There's also some changes to the other pro forma documents that form part of the GCC 2023. So what we really encourage people is to go through the document. Please send us all your comments. There's a specific email address set up at CAASA. It's called gcc2023@caasa.com or .org.za, but it's available on the CAASA website, as are all these documents. Okay, Tiffany, I think we can deal with any questions.
Okay, perfect. Norman, I don't know if you just want to run through the questions from the top.
Sure.
They're in the Q&A box.
Yeah. So we've got from Barry Livesey, says, clarify within definitions the clarification if days relate to calendar or standard working days. Okay, it is certainly calendar days. And I thought that was clarified. I'll check that. Secondly, is any allowance for sessions for subcontractors to be allowed to continue work on the default of principal contractors within the new GCC guidelines? That exists in relation to subcontractors that have been appointed after agreement between the employer and the contractor. It doesn't apply to subcontractors that, let's call them, the common term is domestic subcontractors, that are those of the contractor only. So the work then can be ceded to the employer in the event that the principal contractor goes bankrupt or goes really out of business. Please elaborate on the thinking around the notice that needs to be given by the employer around the time bar. Would this change not undermine the intent of the time bar? Issues are brought to the attention of the employer. Yeah, look, the time barring is always a difficult subject, you know, and it's normally the first reaction of any employer or any employer's agent. You know, you're too late, you're time barred. So what we try to do is open up the opportunity for either party, the employer or the contractor, to dispute the fact that they were time barred, and for the employer to dispute the fact that they were not time barred in that instance. So I don't think it's undermining the intent of the time bar. I think it's only giving clarity and purpose to the fact that, you know, it's often subjective as to when the contractor should have given the notice. And I mean, ultimately, you know, if the parties don't agree, then it goes to adjudication and the adjudicator can decide. So I don't think it's necessarily undermining the intent of the time bar. It's simply giving the contractor and the employer some leeway when the time bar is imposed or should have been imposed. We had a situation in a contract where we had a situation in a contract where the DAB was entitled to overrule the time bar if you could show good cause as to why it should be overruled. Barry asks, arbitration. It allows arbitration based in South African law and South Africa with arbitration refer AOA location within to be nominated. I'm not quite for the arbitration location within to be nominated. Barry, I don't quite understand that question. The arbitration rules, yes, so the default position in the GCC is that the arbitration falls under the Association of Arbitrators, the Association of Arbitrators rules. But we have two arbitration acts. We've got the Local Arbitration Act and the International Arbitration Act. Those were the three questions I can see, Tiffany.
Norman, if you scroll a little bit higher in the Q&A, there are a few more.
I only see opened 3.
Okay. Perhaps I can just read them to you. I'm not sure why it's doing that.
Okay.
All right. So from Tinas, is the term employer's agent still used and not engineer as in previous editions? If so, my opinion is that it sends out a wrong message, as the lead agent using GCC will in almost all projects be an engineer.
Yeah, that was the subject to a long and lengthy debate. And I think all of us that are in the civil engineering industry would want it to be an engineer. But this contract is not just used in the civil engineering industry, it's used in other industries as well. I mean, GCC has been used for building works. GCC can be used for various things. The idea that it is a multidisciplinary contract. So therefore, that was the reason to stick with the employer's agent and not go for the terminology engineer. But as we said right up front, we expect these parties to act in a spirit of mutual trust and cooperation. We expect the employer's agent to be impartial. So although the title employer's agent might suggest bias, that's certainly not the intention.
Okay. Steve had two questions. Are we able to be provided with the comparison tables as presented?
Yes, they're available on the CAASA website.
Okay, and then his next question was, why has clause 6.11 been deleted? What recourse does a contractor now have for drastic changes?
Well, the other provisions of the contract cater for drastic changes. I mean, clause 6.11 was really just a throw-in clause. So, you know, if everything has been exceeded by 15%, then the contractor is entitled to make a claim. But I mean, if the measurement increases, the contractor is entitled to make a claim for an extension of time, for additional payment. If all the other circumstances occurred, then the contractor is still entitled to make claims and entitled to additional payment and or extensions of time. I mean, in all honesty, when we discuss this within our group, there's very few times that this clause has been invoked, as far as we were aware, and hence the decision to do away with it.
Okay, then Steve had a further question, clause 9.1. In quotation, during currency of the contract. What if these events occur after the tender period but before award?
Sorry, just repeat that, Tiffany, I didn't quite hear it.
Okay, so referring to clause 9.1, and he's got there in quotations, during currency of the contract.
Yeah.
And then the question is, what if these events occur after the tender period but before award?
Let me have a look. 9.1. I just need to read it. So what you're saying, these accepted risks occur?
Yeah, during currency of the contract.
Yes, during the currency of the contract, then the accepted risks occur. Yeah. So his question is, what happens if it happens during the tender period?
But before award.
But before the contract award, when clearly then this clause doesn't really apply, does it? I mean, if something happens in the world and the contract has not been awarded yet.
Okay, Steve, I don't know if you want to unmute and you can.
Yeah.
Okay, I see. Yeah, he's raised his hand.
Yeah, please.
Yeah, thanks. Just sometimes with tender periods these days, particularly in the public sector, a tender award can be delayed by 3, 6 months or even longer in some situations.
Yes.
And a contractor puts his price and then the employer is entitled to accept that price based on the form of offer. They accepted 6 months later, but clearly those events took place in the intermediate 6 months.
Yes.
This clause says, well, sorry, the contractors can't do it. So it's a challenge that needs to get resolved somehow.
Yeah, look, I hear what you're saying, and I mean it does happen that contracts are delayed, the award is delayed and delayed and delayed. But you know, until you actually have a signed contract, the GCC doesn't exist.
Sure, but it comes out as a tender based on that. That's the basis which the guy puts his price in, and in all fairness, otherwise they've got to go into long negotiations and change the conditions, and then that would be seen unfair in the public sphere, because now you're talking to one guy and not talking to the others, etc., the whole complication. So I just think some thought should go around. We're not going to find an answer now. I'm raising a question.
No, Steve, thanks for the observation. We'll certainly take it to heart. Okay, I see I've got a comment here from David Glendinning. It says, given that 2023 is not a complete rewrite and given the slow uptake of the 2017 FIDIC suite, is the committee proposing steps to either encourage a wholesale move to 2023 or the more draconian measures such as removing 2015 from publication? The answer is yes, 2023 will supersede 2015.
Okay, then I see Mike has raised his hand. Mike, I've allowed you to speak. You can just unmute.
Hi, sorry, just a point on the extension of the tender validity. There's a recent court case on the extensions of tender validities that where a government entity seeks to extend the validity, unless all bidders agree to the extension is invalid. And secondly, once the tender validity period has gone past, the tender is no longer valid, it's stale, so it has to be re-advertised. So normally for government projects, the validity is 90 days. That's, if I'm not mistaken, in terms of the Public Finance Management Act or the Municipal Finance Management Act. And I think our courts now are becoming quite strict with the applications of these regulations. So it shouldn't be a case of a tender that is awarded after 6 months. If it's not done in 90 days and the bidders don't agree to an extension, then the entity will have to re-advertise again.
Thanks, Mike.
Okay, I don't see any further questions unless somebody would like to raise their hand and ask a question.
All good.
Yeah, okay. I think we're all good, Norman.
All right, thanks everyone. Just to reiterate that really we want your comments, and that there's a pro forma sheet to provide comments on the CAASA website. If you go to the CAASA website, you'll see the full contract, all these comparisons, a comment sheet, and a couple of other things. Also, a little brief history of how we arrived at where we are today. And the closing date for comments is the 30th of March, the end of this month. We'd really appreciate your comments. So thank you very much for taking the time to go through, which is probably quite a bit of a dry subject. But hopefully at the end of it, we have a contract that we're all proud of, that satisfies the industry and lives up to our expectations. So thank you very much.
Many thanks. Appreciate it.
Thanks, Norman.
Thanks, everyone.
Thanks, everyone.